Good evening, everyone. I'm happy to be back with you today, and I'm ready to talk about the judiciary. This is going to be a very exciting topic because I think that you will have an idea of just how relevant it has been to our lives of late. It was only a couple years ago that the Supreme Court, in a landmark case, Dobbs versus Jackson Women's Health Organization, declared that Roe versus Wade, one of the most important and most controversial cases of the last 50 years, giving women a right under the Constitution to get an abortion in every single state, or declaring this right, I should say instead, this decision was overturned. And so the judiciary is a topic that is very much being given new questions and that people are interested in getting to the bottom of today. And so I'm looking forward to hopefully shedding some light on this much discussed but I think little understood topic of conversation. Now, just a couple of sort of procedural remarks here. Wanted to tell you all that fortunately the eye infection that had me pretty hobbled last weekend and into the early parts of last week. That eye infection has totally disappeared, so I'm basically back to normal now. Thank you for your patience last week and for working with me as I tried to recover from that problem. As far as upcoming assignments, I mentioned this already in the announcements, but just again, keep on your radar the final research project, week 8, that's next week. You have your presentation due, and week 10 is when the final paper is due, which is going to be a very huge portion of your grade. So make sure you get those things moving. And please, if you have not done so already, confirm with me your topic or your case from the list of cases in the week 1 folder. As for this week, your only assignment is the discussion post. So let's dive right in here. As I like to begin, I always like to begin with a brief review that connects the topic of today with the topic of last week. You hopefully remember that in our last week's lecture, we reviewed and we analyzed the constitutional philosophy of the American presidency. We often take the presidency for granted, as I said last week, but I think that this obfuscates that it was actually a strikingly original office. Never before in modern times had you seen any republic with anything like that. You had never seen a strong executive that had still retained this very popular foundation for political authority. This highlights to us that for the framers, to the Federalists who designed the Constitution, there was this belief that passionate and rash majorities can sometimes be a threat to the liberties of the people. Sometimes it turns out that the worst enemy of democracy or popular government is actually unchecked pure democracy itself. There are some ways that Constitution should limit the people. And the presidency was very much designed according to that philosophy. It was designed as a safeguard, as a constitutional and limited kind of instrument to impose checks on majority factions. Perhaps the best way to defend the liberties of the people is to limit actually what they can do under their own constitution. The federal government should not be able to do anything under the whim of a rash majority. There have to be these checks and balances here. And so in any case, the presidency came directly from this philosophy. It came about because there was a belief that majority factions were dangerous and that these factions could often be expressed in the Congress, and they might violate the rights of the people and the rights of states alike. What the framers hoped would happen was that this complicated and complex system of checks and balances would ensure that, in Hamilton's words, the deliberative sense of the community would in all things prevail. And I say all that not simply because it's review, but more importantly because it's an important aspect of today's unit. At every turn, the American founders are worried about this problem of majority faction, the problems of pure democracy. They fear that republics can often devolve into this pure democracy, and that this devolution would threaten the rights and liberties of the people. While the framers, to be sure, embraced a democratic government that was based upon the consent of the governed and that was ultimately popular in its foundation, they recognized that checks on democracy could actually help to preserve this popular character by infusing the government with an air of stability and wisdom and deliberation. The presidency and the Senate were both designed as institutions that would do these kinds of things. They were both meant to check majority faction and keep government deliberative. Today we're going to see that this same philosophy is at work as we look at the third branch of the federal government, the judiciary. The judiciary was designed to be yet another institution that could circumscribe powerful majority factions when they arose and give the federal government this air of stability and wisdom. Even more than the presidency and the Senate, however, the judiciary was insulated from popular control. Notice the difference between the term lengths of presidents and senators. The president has a moderately lengthy term in office at about 4 years. The Senate an even lengthier term at 6 years. Well, this pales in comparison to the job security of a judge on a federal court. Remember that if you're a member of the Supreme Court or a member of a federal court that is appointed by the president and confirmed by the Senate, you serve for good behavior. This means that you, in effect, have a lifetime appointment. You can only get rid of these justices when they retire, when they die, or in very rare cases are ejected through the impeachment process. And so this independence of the court ends up being a very controversial element of its character, one that caused people to raise a lot of questions even from the beginning. Notice here these quotations I have. One from the Federalist Papers by Alexander Hamilton and one from a critic of the judiciary, the anti-federalist Brutus. To Hamilton, the complete independence of the courts of justice is peculiarly essential in a limited constitution. It is this independence that is guaranteed by things like the good behavior terms for justices that ensures that it's going to actually work for the people and protect their rights. Meanwhile, the anti-federalist Brutus, he says actually this independence will have the exact opposite tendency. It's going to guarantee that these judges do not really see themselves as accountable to anyone. They are independent, Brutus says, of the people, of the legislature, and of every power under heaven. Men placed in this situation will generally soon feel themselves independent of heaven itself. So independent are these justices, Brutus and other anti-federalists warned, that they will be essentially unaccountable even to God himself. Or at least they will feel themselves as unaccountable to God himself. In actuality, they are not, but they won't fear the consequences of God's wrath on them because they think they can do anything, right? So these are two entirely different views of the judiciary, with Hamilton saying this is going to be one of the best things about it, and Brutus saying this is a recipe for disaster. So today we're going to try to understand these things. And another important point to keep in mind is that the judiciary was actually conceived as the weakest of the three branches, even by the Federalists. So even people like Hamilton, who argue for this independent judiciary, they still believed that the judiciary had its limits and that the Constitution imposed limits on a judiciary. So there are major disagreements here. So let's see here. The first place to begin, if we want to understand the importance of the judiciary, is Article 3 of the Constitution. This is actually one of the shortest parts of the whole Constitution. The whole document, it has 5 separate articles. Article 1 deals with the Congress, Article 2 with the presidency, and Article 3 with the court. There are 2 additional articles at the end that deal with other matters. But Article 3 is the shortest of the institutional portions of the Constitution. And this, I think, is very revealing. For one thing, it teaches us that the framers didn't really expect the judiciary to be all that important, at least not when compared to Congress and the presidency. But I think it also highlights to us that they expected that in many ways the judiciary would be given shape and definition by acts of Congress after the Constitution's ratification. Remember that the only federal court established by the Constitution is actually the Supreme Court. All other federal courts are created by the Congress and exist basically under its mission and mandate and authority. So with all that said, why do we need a court at all? What does this article here mean? That the judicial power to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority. What is the meaning of this? Well, the reason we needed a court was quite simple. The founders were very much informed by the British experience here as in many other places. And they had seen that for much of British history, liberty had always been connected with the independence of the courts. Before the English Civil Wars began, King Charles I often sought to bring the courts under his thumb, and he would use them in ways that would control not only his execution of the law, but also its application when it was being arbitrated by judges. Remember that the separation of powers is important because if you have this concentration of power where a law can be executed against someone and then guilt or innocence is decided by the person doing the executing, well, this is a recipe for abuse and corruption. And so one lesson from the British experience was that the judiciary needs to be independent of executive control. The founders knew that this would lead to similar abuses of executive power if we didn't apply that lesson in our own system. Just think to yourself that if the judges served at the pleasure of the president, you could imagine how fast President Trump or President Biden would remove various judges, even those of their own party, simply because these judges issued decisions that sometimes they don't like. And so the founders know that you've got to keep the courts independent of the executive. But I want to stress that it was equally important for the judiciary to be independent of legislative control. In fact, that's even more important in a republic where the legislative branch predominates. If the legislature can tell the courts what to do all the time, then the courts cannot correct them when they violate the Constitution, as they would likely do when or if they come under the spell of powerful and rash majority factions. And so the court is meant to be independent not only of executive power, but also of the legislative power, because it is meant to be a check and balance against them. So the first thing I want to look at here as we understand the purpose of the judiciary is this idea of cases and controversies. Under the Constitution, the court always operates in this context of cases and controversies. I want to spend just a bit of time on this because it's deceptively simple, but the truth is important to understand. What does this mean here, cases and controversies? Well, what it means is that The court is always deciding on cases that exist between actual individuals or between individuals and governments. So these are concrete cases, things that are actually going on, disputes that are really taking place. Unless this seem obvious, a good contrast would be thinking about what Congress does. Congress isn't limited by cases and controversies, but it's deliberating about what the law ought to be, right? So it's dealing with hypotheticals and with kind of abstract formulations about what we need to do and what we should enshrine in the law. The president, too, is making decisions about how these laws are executed and who has violated them. But the court alone is the one that sort of gets to serve as this constitutional place of last resort for individuals to go to have their cases heard and decided upon. These are not hypothetical cases about something that could happen under existing law, but they're real disputes that inevitably arise under existing law that require some kind of settlement. You can see why this sort of thing is inevitable in a republic. You have all kinds of laws passed under the authority of different congresses and different state legislatures at different times. Sometimes sometimes the way these laws should be interpreted is pretty clear. But other times it's kind of messy, right? Sometimes new laws seem to contradict some statute that was passed 10, 20 years ago. What do you do in these cases? So, for example, when Biden issues an executive order saying, oh, well, I'm going to forgive student loan debt because the statute was enacted after 9/11 that gave the federal president some authority to forgive loan debt of veterans, well, the court has to decide, is that what is going on in this law or not? So these are real cases and controversies between actual individuals or between individuals and institutions. So this is why every case you see before the court has names of people or institutions in its title, or governments. So Roe versus Wade, Planned Parenthood versus Casey, Griswold versus Connecticut, these kinds of cases. They all speak to this truth that the controversies that the court is trying to settle are real disputes arising under existing law, not hypotheticals. A second important distinction that I want us to understand is the distinction between criminal cases and civil cases. These are two different kinds of cases that the Supreme Court often has to decide. Criminal cases are fairly obvious to us and apparent. So these are those cases like murder and rape and arson and robbery, the cases that usually involve some kind of act of violence against a person or against the community, or that otherwise undermine the preservation of the society. In a criminal case, your punishment is probably going to be some kind of prison time, right? These should not be confused with civil cases. Civil cases are a little different. These are cases like contract disputes, where you have two parties that disagree about whether or not an existing law applies in their case. So, for instance, some business may fire Joe Schmo. Well, Joe Schmo, who is deprived of his livelihood, he decides to sue this business because he argues that under his contract, he should have been given more notice or had a more rightful cause for his dismissal. In this case, neither of the two parties is likely to go to jail or face any prison time, but the loser will be forced to pay the winner assets, such as money and some kind of award in that sense, or otherwise make them keep the terms of the old contract. So these civil cases are often resolved in what are known as settlements. These avoid the need for a formal sentencing by the courts and allow the parties to resolve the dispute outside of court. Sometimes you hear about how some person, actually recently when President Trump sued CNN, I believe, and this would have been a civil case for defamation, that could have gone to the court, while CNN paid Trump money to settle the case and avoid any kind of formal court action. So these kinds of things happen all the time. The Supreme Court can hear both criminal and civil cases, and some of the cases we're going to study are criminal, some are civil. But somewhat more of its decisions are civil rather than criminal. A final concept I want to make sure we understand before we move to the founding debate over the judiciary is the concept of jurisdiction. This is a pretty simple concept. It is, to put it simply, the ability of a court to hear a case. If the court has jurisdiction, it can hear the case. If it does not, then it cannot hear the case. So why does this matter? Well, this matters because in our federal system, a system which reserves many powers to the states, there are a lot of cases in which the state courts might have jurisdiction, but the federal courts do not, and vice versa. Some criminals cannot be prosecuted by the federal government because their crime violated state law, but not necessarily federal law, meaning that it is up to the respective states and their governments and criminal justice systems to bring them to justice. Now, I want to be clear here. Whenever I was in 11th grade myself, I remember thinking, well, wait a minute, murder is a state crime under state jurisdiction, but it's not a federal crime? That's crazy because murder is so bad, right? Well, I want to be clear here about why that is not something we should be concerned about. So contrary to what 11th grade me thought. So the misunderstanding here is that sometimes we have the assumption that the federal government is always handling the important stuff and the states are kind of lesser entities that don't deal with things that matter. Well, no, that's not what's going on here. It is not the case that the worst crimes are federal and the lesser crimes are state. No, jurisdiction often involves things like geography and proximity, much more than a moral calculation about whether or not a crime was especially wicked. So think to yourself that some kinds of robbery and murder, these are often state-level crimes and not federal ones, not because they're not horrible, but because the state governments are closer to the issue and they are more capable of investigating it and bringing the perps to justice. Now, in some cases, what begins as a state-level crime can become a federal crime. So, for example, the famous bank robber John Dillinger, I believe, from the 1930s, he had been pursued by the state governments whose laws he had violated in his bank robberies, but the FBI couldn't touch him because he hadn't committed a federal crime. Well, as soon as he brought alcohol, which was still banned under prohibition laws across state lines, now the FBI can do something about it because now the criminal justice system has jurisdiction and he can go to federal courts. So that's what's going on there. It's not the case that states deal with lesser crimes and federal governments deal with the more severe ones. Murder and robbery, these are state crimes often, simply because the states are the most prepared to bring the perps to justice. So how does this pertain to the Supreme Court? Well, the court has two different kinds of jurisdiction. There's two ways that it can hear cases. So original jurisdiction is the ability of a court to hear a case for the first time. So it originates with the Supreme Court in this case. It's the first time the case has gone to court. Appellate jurisdiction, in contrast, is when a case is appealed. So appellate, appealed, right? So it's when a case is appealed from a lower court up to a higher one. The vast majority of cases that come to the Supreme Court are actually appellate cases. These are cases that were heard in a state court or a lower federal court of appeals, but then later reach the Supreme Court because someone successfully petitioned the Supreme Court to hear the case as an appeal. Now, we should be clear here that it is not easy to reach the Supreme Court. Just because you think your case is important and should be appealed and you did not have justice done to you does not mean you have a great chance of successfully having your case heard by the court. In fact, I remember a recent statistic said something like the court had 8,000, 7,000, 8,000 petitions for cases that were requested as appeals cases that the Supreme Court could decide on. Well, in this particular year, the court only accepted 73 of those cases. So a very, very tiny fraction of the cases that are petitioned for appeal are actually heard by the court. If the court wants to take up the case, you have to have something like 6 of the justices on the court basically decide that it's worthy of their attention and that they want to hear it. But because justices are very busy, they often don't want to pick up just any case. They want them to be important cases. So most cases are appellate cases. I believe it's likely that when the odds are that when you study an important court case, so something like Roe versus Wade or Dobbs versus Jackson or Texas versus White, or you take your pick of some important Supreme Court case. Actually Texas versus White might be original, but anyway, most cases are appellate cases. Now, when does the court have original jurisdiction? When can it hear cases for the first time? Well, this is a very rare thing that it can do, but it does happen. The court is given the power to hear cases for the very first time if it is a case involving disputes between the states, or cases that involve public ministers or ambassadors. So that's why I hesitated there with Texas versus White, because it is a case involving the state of Texas. But now that I think of it, it probably was appellate, since it was White suing the state of Texas, and this probably went to the state court first, and then eventually found its way to the court. So I don't know about that one. But let's take a better example. California versus Texas. That's one that is definitely an original jurisdiction case, because you have 2 states that are involved in a dispute with one another. One is suing the other, and you can't really appeal that to just one single state court, right? It's a national, it's one involving that needs federal action. The court also has jurisdiction that's original in cases involving public ministers or ambassadors. So these are cases like Chisholm versus Georgia, where you have some kind of a public minister who is suing the state of Georgia, and this dispute goes before the Supreme Court. And so these are important issues to establish what the purpose of the court is today. What does it do? At the end of the day, the job of the Supreme Court is to do justice, right? It's meant to do justice to the aggrieved parties, and it's meant to be impartial and disinterested in the application of the law. As we all know, justice is blind, right? That's why we have in the Supreme Court building the statue of the Lady Liberty with the blindfold on, right? It shouldn't matter what the person looks like or who their father or mother was. The law should apply to them the same way it does to anything else, to anyone else. This is one of the great distinctives of a free democratic political system. But what if the Supreme Court's design was such that it actually was more likely to be a force for injustice? This was the argument of the Anti-Federalists. And this brings us to the writings of the New York Anti-Federalist Brutus. Of all the Anti-Federalists, he is the one who by far spent the most time on the subject of the judiciary. He's also the one that is most certainly the most prophetic and prescient in his analysis of some possible trends and issues that might emerge under this new constitution in the judiciary. From one angle, it's not really that surprising that we see Brutus here worry about the powers of the courts. At every turn in our earlier studies of federalism and anti-federalism, Brutus seemed to be quite critical of the new Constitution and a believer that it's going to be manipulated and twisted for very evil purposes. That said, the judiciary warrants a kind of special ire on his part. He believes that it is much more poorly designed than either the executive or the legislative branches, as badly as those were designed too. Brutus acknowledges that those branches do have some serious checks and balances that might mitigate against especially overt forms of corruption. But as he sees it, the judiciary is fundamentally different. He argues that in their effort to make the Supreme Court independent of public opinion, the framers went way too far. They've rendered the justices independent not only of majority faction, but really independent of the nation itself. Heck, even of God himself, as I mentioned. They are to be rendered totally independent, he writes in Brutus number 11, both of the people and the legislature, both with respect to their offices and their salaries. No errors they may commit can be corrected by any power above them, if any such power there be, nor can they be removed from office for making ever so many erroneous adjudications. And just remember that quote from earlier. Men placed in this situation will generally feel themselves independent of heaven itself. So these are justices who are going to make up their own rules. They might even try to usurp the powers of God himself and declare themselves independent of his rules. One of, I think, the more amusing and sadly prophetic predictions that Brutus makes is he says the court, they might make up rules and then the branches are just going to pretend that those rules are legitimate. So the court's going to sort of write its own tests and write its own regulations and say, well, this is what the Constitution means, and the president and the Congress are just going to sort of passively accept that. I think of things like the Supreme Court's famous Lemon test, right, which is what they've used to decide when you can pray in public and things like this. And it's like, well, there's nothing in the Constitution about a Lemon test, but the court has, in effect, written it into the Constitution by interpretation. And then worse still, Congress has just allowed it. That's exactly what Brutus is talking about here. So why does Brutus believe that this judiciary is so poorly designed? Well, there are several different arguments here that are worth our time. And the first major argument that I want us to be clear about is his argument that judicial review is basically going to be abused and perverted into what is today known as judicial supremacy. This is a core concept of today's lecture that we're going to explore again when we get to Alexander Hamilton. And so if you don't quite understand it here, keep listening because we will talk about it again with the Hamilton discussion, because this is a core concept that we have to understand. So, judicial review. This is, simply put, the ability of a court to declare laws passed by the Congress to be unconstitutional. So, Brutus isn't an idiot, right? He understands that if you have a system based upon the authority of a written constitution that's above the authority of a legislature, you're going to need something like judicial review to some extent. Because at the end of the day, if the Congress passes a law that is in blatant violation of the Constitution is the boss, and the court should be bound by that same Constitution and not just passively rubber stamp whatever the Congress says. So Brutus isn't an idiot. He understands that there's some need for some kind of judicial review here. However, he believes that the court is going to use its powers to decide cases and issue decrees from on high that basically redefine the Constitution for other branches. And so this is something that transcends mere judicial review and becomes something more like judicial supremacy. He thinks that this kind of thing is inevitable because under the Constitution, he says, the court might have the ability to decide cases based not on the text of the law, but instead upon the spirit of the law. So, for instance, the justices on the court, they might say, well, the spirit of the law is liberty. And we know that Christianity is a threat to liberty now because we're progressive and enlightened, and we know that Christianity promotes backwards ideas about marriage and family. And these atheist justices, they might say, well, the spirit of the Constitution is liberty, and we know that we can act for the general welfare because of the general welfare of the General Welfare Clause. And so, voila, in a decision, we're going to say the Constitution declares atheism as the national religion. And Brutus says there's nothing that we can really do about this because there's no Bill of Rights to clearly explicate that there are certain things the federal government cannot do. So remember, there's no Bill of Rights yet. That comes later as a way to place the Anti-Federalists, actually. And so right now, Brutus is like, hey, the court's just going to use these general statements about the general welfare in the preamble, and it's going to declare decisions based on the spirit of the Constitution rather than the text of it. And so this is obviously going to destroy the concept of limited government under a limited constitution. Now, this problem is only going to be exacerbated by the fact that, as Brutus sees it, the other branches don't really have enough tools to challenge the judiciary when it usurps these kinds of powers. So, interestingly, Brutus reads Congress's impeachment power fairly narrowly. We're going to see he actually reads it a little more narrowly than Hamilton does in Federalist 81. And so Brutus suggests that when judges usurp power under the Constitution, he says that a strict application of the text says they can't be removed for doing so. So Brutus says the only way you can remove these judges is for high crimes and misdemeanors. This means that if they misbehave, if they do bad things that usurp power and that twist the Constitution, you can't just impeach them. And so this means that impeachment isn't a good check and balance, according to Brutus. Brutus also thinks that another possible tool in their arsenal is similarly going to be rendered irrelevant. So Congress actually has the ability to decide what cases the courts can hear, both the federal appellate courts as well as the Supreme Court. They can potentially alter the jurisdiction of courts. And so that is a possible check. You could imagine that if Congress had been really upset by Roe versus Wade in the 1970s, they could have theoretically passed a law saying, well, actually, this is no longer in the court's jurisdiction, this issue of abortion policy. We revoke it. We revoke this particular topic from their jurisdiction. That's something that in theory they could do. But Brutus isn't convinced that that's going to happen or that that's going to really be a check on the court's power. And I think he's actually been proven right about this because it's very rarely ever happened that Congress has tried to alter the jurisdiction of the court as a way to punish it or check it. The only time I can even think of this happening was during Reconstruction, when Congress was on the ascendant and seemed to think there was nothing it couldn't do. But in any case, the reason Brutus argues that this incentive isn't going to be there, the reason you can't trust Congress to just take jurisdiction away from the courts after it makes bad decisions, is that the courts and the Congress are basically going to be on the same team. They both work for the federal government. They're both parts of the national authority. And they're going to count on one another to basically lend support to their own mutual usurpations. The enemy to Congress and the court, as Brutus conceives it, is going to be the state governments. And so Congress is going to interpret its power broadly to do things that violate states' rights. And when this happens, the court is just going to rubber stamp it because the court doesn't want to see power go back to the states. It wants similarly to see new powers amassed in the federal government because that in turn gives the Supreme Court more power. And so basically, the court's always going to side with the consolidationists, with the big government people. And it's always going to want to strip powers away from the state governments. This is Brutus's argument. Because the national federal government is always going to have some interest in expanding its authority against the states. And so you can't really trust the Supreme Court to stop Congress from abusing its powers, and you can't trust Congress to stop the Supreme Court from abusing its powers. Because the real problem is that so much power is centralized in the national authority against the states. So, wrapping up Brutus here, the first thing you'll notice is that Brutus is remarkably prophetic about the modern Supreme Court, especially as it existed between the 1940s and the 1990s, when it was dominated by progressives, liberals, and judicial activists of various stripes. So William Brennan, who is one of the most powerful and important liberal activist judges in American history, William Brennan once said that his only rule that he used when he decided cases under the Constitution was what he called the Rule of Five. Brennan said, "So what is this Rule of Five?" someone asked. And Brennan said, "Oh, it means if you have 5 judges, you can make the Constitution mean whatever you want it to mean." So the Constitution, as Brennan and other activist judges understand it, provides only a vague roadmap for liberty, and its details are meant to be filled in by activist judges in ways that accommodate the times when times change, when things move forward. So this is a proclamation of judicial supremacy, of the exact kind that Brutus had criticized. Combined with the doctrine of living constitutionalism, the idea that the court can just squeeze out evolutionary meaning from the Constitution and alter it basically by fiat, this philosophy undermines the principles of popular government by the consent of the governed. And so if Brutus is right here about the dangers of judicial supremacy, then William Brennan and other liberal activist judges have totally misconstrued the nature of our Constitution and the nature of Republican government. And so is this the final word? Does this mean, well, the Constitution was poisoned from the beginning? Because, shouldn't we just throw up our hands and say, well, the Constitution was ratified, so Brutus and the other anti-federalist opponents who wanted a limited judiciary, they failed, and we ended up with an imperial judiciary, and this was the framers' fault, right? That's one response people could potentially have to Brutus's warnings. But I want to highlight that actually the Federalists are on the same page with the Anti-Federalists in rejecting these doctrines of judicial supremacy and living constitutionalism. In arguing for the new Constitution, the Federalists insisted actually upon the limited powers and the limited function of the judiciary in the system. So they didn't say to the Anti-Feds, oh yeah, you're right, this is an incredibly powerful court, and here's why that's awesome. No, the Federalists rejected the basic premise of the anti-Fed argument. The Federalists said, no, the court is designed to be a limited institution, here's why, and ultimately it has a moderate but important purpose. It's meant to be a defender of ordered liberty, and it's going to be a great safeguard not only to the rights of individuals, but to the rights of the states. And so in a way, he turns the anti-federalist criticism on its head by saying, no, if you want a constitution to protect the rights of the states, you need this power of judicial review. And here's why it's going to function in this way that basically infuses an air of conservatism into the constitutional system. So I want to unpack this argument by looking at Federalist 78. This is one of the most famous of all the different Federalist essays. I think that even though it is one of the most famous of the Federalist essays, we sometimes neglect to mention that it was actually written as an explicit response to the letters of Brutus. So this is a Federalist essay that clearly has in mind the letters of Brutus and shows that Hamilton himself was troubled by the argument that the Constitution is going to create an out-of-control judiciary. The reason Federalist 78 is so important and so famous is because it lends credence to the idea of judicial review. So judicial review is not actually mentioned in the Constitution explicitly, but it was basically interpreted into the Constitution pretty fast by Justice John Marshall in Marbury versus Madison. And Federalist 78 shows that Marshall doesn't really invent that out of thin air, but no, actually, judicial review is based upon the clear language of the Constitution. It's an implied power under the Constitution, and Hamilton anticipates it and argues for judicial review here in Federalist 78. So that's one reason it's very important. So Hamilton wants to persuade people to ratify the Constitution. Remember that that was the mission of the Federalist Papers in general. But to do that, he's going to have to allay these anti-Federalist fears that an activist judiciary is going to be able to twist the Constitution in ways that destroy Republican government and threaten the liberties of the people. So the first important point that Hamilton highlights for us in Federalist 78 is the need for judges to serve terms during good behavior to protect their independence. Judges should not be elected, as we in many of our states actually allow for. Many of our state constitutions have state Supreme Courts whose members are all just chosen by popular vote, right? And that's clearly in violation of it's not a violation of the federal Constitution, but it rejects the philosophy of the federal Constitution for something more populist, right? But instead of having judges be elected, Hamilton says they should be indirectly selected by popular officials. So the president nominates and the Senate confirms. And because these are still political branches whose officers are ultimately accountable to the people, the court itself is not totally isolated from the public. That said, this good behavior entails that once these justices are there, they shouldn't have to go up for reconfirmation every few years. If they did, this would mean that they would make decisions with a view to currying favor with the legislature or with the president, rather than trying to protect the Constitution, even if that means making those other branches mad at them. So if the president can just remove a judge that makes a decision they don't like, well, that's not going to be an independent court. And that's not going to be a court that protects the people from presidential power, for instance. So in effect, a term of good behavior amounts to a lifetime appointment, barring impeachment, death, or resignation. It's a way to guarantee that these judges are going to be more likely to act in ways that are independent of legislative or executive control. I do want to emphasize that in some ways Hamilton's focus on this issue is actually something of a straw man, because even Brutus never really questions the need for judges to have lifetime appointments. So Hamilton is attacking an argument that Brutus never seemed to be making, right? Brutus is taking up a lot of issues that he has with the court's design, but I don't believe he really goes after the good behavior aspect. I think that he is worried about other things that render the court unaccountable, and good behavior added to that just gives it another way of being isolated from public opinion that could be dangerous to liberty. So this is something of a straw man, but nonetheless it is a good argument for why the framers wanted good behavior, even if Brutus himself didn't quite reject that. So the next major important point is this critical distinction between judicial review and judicial supremacy. Today, these concepts are often confused and mixed together. We think that the court has the power of judicial review, and this means it's also the supreme institution under the Constitution. Well, this is not actually the case, as Hamilton himself tries to show. Brutus had kind of conflated the two, or at least he had said there would be a close connection between the two. Brutus had said that the court's power of judicial review would basically guarantee that over the time it would amass these powers of judicial supremacy. But Hamilton stresses that judicial review is not the same as judicial supremacy. So, again, what are these things? Judicial review is, again, the ability of the court to decide whether laws passed by Congress are constitutional or not. They can potentially strike down a law for being unconstitutional. This power is not explicitly mentioned in Article 3, as I've already said, but it flows directly from the court's ability to decide cases and controversies. So just think about it logically here. If the court is going to resolve disputes that arise between individuals under the Constitution, then it's going to have to determine what the law in question actually says under the Constitution in order to come to any resolution. And so judicial review is in some ways a means to this end of deciding cases and controversies. Well, under this philosophy, the final authority for all three of our branches is the Constitution. It was only the Constitution that was ratified by the American people. If we take popular sovereignty seriously, then no one single branch can assert supremacy over the others, because each of them derive their authority from the same exact master, the American people who have established this Constitution, we the people. So this is not the same as judicial supremacy. Under the doctrine of judicial supremacy, the Constitution, as Chief Justice Charles Evans Hughes once said, means what the Supreme Court says it means. So again, the Constitution means whatever the court says it means. Well, this would mean that the court is not bound in any meaningful way by the Constitution as its final authority. Rather, the court can update and change the Constitution's meaning in order to get it in tune with the needs of modern times. So basically, the court can seize for itself the role of being a constitutional convention and just change the Constitution all the time because it knows what the people need better than the people themselves do. And so if the court has spoken according to this philosophy, then the other branches are helpless and they need to allow the court's will to be done. They can't challenge it because this is a threat to the authority of the court and judicial supremacy. So this shows a very serious misunderstanding of the powers of the court, according to the founders. The framers were very clear about the importance of the rule of law, but at the same time, they never conceived that the court would be able to decide the extent of its own powers or that it would be an institution that would essentially be unchecked by the other branches. If the court has this basically unlimited power to not only determine the extent and nature of its own powers, but also the powers of its rivals in the other departments of the government, which could potentially check it, like the legislative and executive branches, then the American people are no longer in charge of their own government anymore. The court is, right? And the court is, of course, the least representative of all of our different institutions. It's the one that's the least accountable to popular control. And so Hamilton in Federalist 78 explains that the court is actually meant to be the least dangerous branch. The legislature has the purse. The executive has the sword. So one has the will and one has the force. But all the court has is judgment. If the other two branches want to oppose themselves to the judgment of the court, Hamilton's argument suggests that they can do so. There are ways that the executive and legislative branches can challenge the court that don't necessarily undermine the independence of the court or its legitimate constitutional authority. So let's take an interesting example of this that I think shows the incredible weakness of this judicial supremacy argument. Dred Scott versus Sanford, one of the most notorious of all the Supreme Court cases in the history of the United States. A case that was notoriously racist because it upheld and entrenched the institution of slavery and declared that blacks could never be citizens under the Constitution, which was clearly, by the way, not a constitutional decision. That's not right. In some of the states at the time of the Constitutional Convention, free blacks were citizens. So this wasn't even an originalist decision. But in any case, Dred Scott versus Sanford. This is important here because this wasn't just a racist decision that's backwards by modern time standards. It was that. But it was also a case where the court asserted something like judicial supremacy. So the Supreme Court in this particular case, Dred Scott versus Sandford, they in effect banned Congress from doing something that they had done for many decades under the Constitution, which was regulate slavery in the territories. So the court asserted judicial supremacy and said, no, Congress, you can't do that. And we say so, we're the final word on the slavery issue. So shut up and get out of the way now. This decision was meant, in effect, to outlaw the new Republican Party, which had had a political platform that stressed the need for Congress to restrict the spread of slavery into the territories. And so what do you do in the face of this kind of judicial supremacy, and as it was applied in the Dred Scott versus Sandford case? Well, Abraham Lincoln, he could have just said, well, the court has spoken, so our business with slavery is done, and we've got to just accept it, right? That's something that would have satisfied that day's believers in judicial supremacy. But Lincoln didn't say that, and he actually articulated, I think, the legitimate constitutional principle that is taught in the Federalist Papers. He articulated a principle known as departmentalism. That's worth writing down, actually. I should have put that here. So departmentalism. All three branches. All three branches are coordinate pieces of the constitutional pictures. All of them are okay, so so all three of the branches, legislative, executive, and judicial, are coordinate and interpretative authorities on the meaning of the Constitution. No one branch has the unique authority to interpret the Constitution, but all of them have to do so. Remember that not only does the court have to interpret the Constitution when it decides cases, but the president swears an oath to preserve, protect, and defend the Constitution. Well, this requires that he interpret it. Similarly, the Congress swears an oath to uphold the Constitution. This means that they have to interpret it, right? And so each of the branches was meant to work for the people under the Constitution, and all three of them were meant to interpret the Constitution as they saw fit. The court has this unique power to decide cases and controversies, and that's a very important power, as we have already tried to understand. And so what Lincoln would say here is that in this case, Dred Scott versus Sandford, while the individual case involving Dred Scott had been settled, unfortunately, and while this meant that Dred Scott himself could not be given the rights of citizenship unilaterally by the president unless you have a constitutional amendment, what we can do is have Congress pass new legislation for future use. So Congress can pass new legislation touching slavery in the territories in order to force the court to touch the issue again. And the president, for his part, can do as Lincoln himself does. Lincoln, he didn't simply give Dred Scott his citizenship back because he knew that under this separation of powers doctrine, he unfortunately couldn't do that. But what Lincoln did was he said, well, I reject the constitutional reasoning of the court, and so I'm going to still issue passports to African Americans under the auspice that they have citizen rights under the Constitution. And so there are ways that the other branches of government can respect the court's ability to decide cases while they also take their own action that protects the Constitution in their own day and age. And so this example of Dred Scott versus Sandford speaks to us about the weakness of the judicial supremacy concept. But it also teaches us about the importance of the idea that at the end of the day, every branch of government works for the American people. No one branch of government is meant to be the supreme authority with the unique power to decide the meaning of the Constitution. But the Constitution is owned by the American people. I think James Madison put the matter quite well in Federalist number 49. Madison writes there that the several departments being perfectly coordinated by the terms of their common commission from the people, it is evident that none of them, including the Supreme Court, I should say, quote, can pretend to an exclusive and superior right of settling the boundaries between their respective powers. So if the court is the final authority, and if the other branches can't do anything when the court does something unconstitutional, well, the people cease to really be in charge of their own government at that point. So a last important point to mention here about Hamilton's defense of judicial power is his response to Brutus's claims about the weakness of the impeachment power. Hamilton in Federalist 81 actually says that Congress will have the ability to punish recalcitrant judges. Hamilton contemplates the use of the impeachment power to punish judges for usurping power, not simply for high crimes and misdemeanors. So in a way, it's kind of interesting that Hamilton, who is not known for being someone who wants to touch the independence of the court, in a way it's interesting that he's actually contemplating this kind of a political use of the impeachment power. So in Federalist 81, he writes of impeachment. He says, "This is alone a complete security. There never can be danger that the judges, by a series of deliberate usurpations on the authority of the legislature, would hazard the united resentment of the body entrusted with it, while this body, the legislature, was possessed of the means of punishing their presumption by degrading them from their stations." So while Brutus had predicted that Congress is going to have a very narrow view of the impeachment power, Hamilton argues for a more aggressive use of the impeachment power to check and balance judges when they violate the Constitution. So what Hamilton would say in response to these liberal activist judges like William Brennan, he would say that in a way we shouldn't only blame Brennan for these violations, but we should also blame the Congress, because Congress has let people like Brennan keep their jobs even after they've made decision after decision that's shown that they have no respect for the Constitution and only respect this idea of the rule of five, right? This idea that you can just twist the Constitution into whatever you think it needs to say. And so this is a very fascinating argument, and unfortunately, I will say that history has basically played out Brutus's prediction more than Hamilton's. I would be in favor of a more aggressive use of the impeachment power to punish bad judges. So I agree with Hamilton's argument in principle. But unfortunately, for various reasons that it would take too long to get into, Congress over the years has basically decided to not ever impeach the court for bad behavior. And so this important check on judicial tyranny has been neglected by Congress. I don't want to spend very much time at all on the other Federalist essays, because their concepts are simple and straightforward. Federalist 79 defends the inability of the Congress to lower the salary of court justices. And this makes a lot of sense, right? This ability, so if Congress had the ability to lower a court justice's salary, well, this could basically bribe the justice and say, we're going to dock your pay if you don't behave in ways we like. The framers are interested in the separation of powers, and they understand that this fixed salary is something that can protect the independence of the court from legislative control. Federalist 80. This is about the need for the court to be able to impose some uniform standards throughout the various states, even when those states are doing things that violate the Constitution. So basically, this is about the need for a measure of supremacy over the states. So no state should be able to print its own money, and the court should have the ability to knock them down when they try to do so. But at the same time, the states are still reserved many powers to themselves under the Constitution, and the court shouldn't try to abuse this power. In next week's lecture, we're going to see that one important turning point in the history of the court is the 14th Amendment. because this is the amendment, long after the founding, 1867, 1868, that gives the federal government for the first time a weapon to basically go into the internal affairs of the states and tell them what to do all the time. And so many of the decisions that we're going to look at next week involve a very loose interpretation, not really of these constitutional texts we've been talking about, like the necessary and proper clause or the general welfare clause, but rather a very loose interpretation of the 14th Amendment, which guarantees that all states must protect due process of law under the Constitution, which is seemingly narrow in its scope, but has been applied by the court in very extreme ways. So we're going to see how abortion on demand and contraception in every state and porn in every state and go down the list of all these different civil liberties and civil rights related cases. They emanate from the judiciary's application of the 14th Amendment. And this, combined with the principle of judicial supremacy, has done enormous damage to our constitutional system. So today's discussion has hopefully set you up to understand the reason for the contested position of the court today. A lot of the political battles over the nature of the court derive from some of these same debates that we've looked at. Next week, we're going to look at concrete examples of court cases that have forced us to come to new understandings of civil liberties and civil rights. So if today was about the principles of the court, next week is going to be more about the court at work. What has it actually done? What are some examples of important cases in the court's history? So in order to set us up for that discussion, I want to, here in our conclusion, just establish two important debates to define and keep in mind as you do your readings for the next week or two. So the first debate is over the role of a judge in our system. What is the job of the judge? Should he be an impartial adjudicator, as the founders envisioned? Or should he or she use their own moral and political beliefs to advance progress as they understand it? So the first of these beliefs is judicial restraint, and the second is judicial activism. So judicial restraint stresses the inability of the court to serve as a super legislature and says, no, judges, they need to be kind of like referees at a baseball game. You know, they keep the rules. They behave impartially. They don't try to allow their own opinions to shape the way they interpret law. So that's judicial restraint. Whereas judicial activism demands that judges actively use their power to advance progress and settle policy debates and issues. So as you can imagine, judicial activism is often closely attached to this principle of judicial supremacy. A second and closely connected debate, which is not exactly the same, is over how judges should interpret the Constitution. So if the first one is about what is a judge is kind of the first debate. The second debate is over how should judges behave when they get there, or what are the rules that judges should follow under the Constitution. Well, this is the debate between living constitutionalists and originalists. Living constitutionalists believe that the Constitution needs to be seen as an evolutionary document whose meaning can be altered by judges when they see that is necessary. So I want to be clear here that in some ways that name is a misnomer. I'm a constitutionalist, and I believe that the framers' Constitution is alive and well for us today. It still is just as relevant for our time as it was for their time. And so in that sense, all people who believe in the founding are living constitutionalists. But that's not what living constitutionalists believe. They believe the framers' Constitution is dead to us. They believe that we ought to transcend the limits of their time and allow judges to squeeze new meaning out of the Constitution because there are new issues that have emerged that the courts are uniquely suited to settling for the people. So sure, there was no right to an abortion in 1789, but there is now in 2025, or at least there should be, a living constitutionalist might say. So this is about evolution and progress, and it sees the court as an instrument for doing this. And it's not really concerned about what the text of the Constitution really says, because ultimately the Constitution doesn't provide a lot of real guidance or strict rules for us. It's just something that we can interpret according to the spirit of liberty, sort of like what Brutus was saying. So that's living constitutionalism. Originalism, in contrast, is the idea that judges should depend for their decision-making on the original intent of the people who ratified the Constitution, who ratified its amendments. So this is important. It's not only the framers' Constitution, but also the amendments to the Constitution ratified by later generations that have to be interpreted according to original intent. And then also laws have to be interpreted in this way. So this is originalism. It's seen as a way to keep the judges from putting their own policy preferences into law, and as a way to keep judicial authority constrained and impartial. So I want to propose to you that at the end of the day, the writings of the founders, whether anti-federalist or federalist, they reveal that modern understandings of judicial supremacy, of judicial activism, and living constitutionalism, all of these things are incompatible with constitutionalism and with the idea of republican government. If we take the consent of the governed principle seriously, none of these concepts can be accepted. The Constitution establishes three branches of government to interpret it and act under it, not just the court. So that rules out judicial supremacy. Similarly, the court has to answer to the Constitution that the people ratified, not invent a new Constitution through its creative interpretation that no one ever voted for. Whatever one thinks about abortion rights or gay marriage, if they're good, they need to be added into the Constitution via amendment or via congressional law. Added into the Constitution via amendment, not simply imposed by a 5-justice majority on the Supreme Court. So that rules out living constitutionalism. And lastly, the court, when it makes decisions, it's meant to consult not its policy preferences or its own moral values, but it should leave politics to the more political branches while deciding only narrowly on law and the disputes that arise under it. So the court is meant to be the least political of our institutions, not the most political. And so judicial activism is ultimately incompatible with this founding philosophy of republicanism too. And so with all that said, I look forward to seeing you all again next week and continuing our exploration of the judiciary as we look at civil liberties and civil rights. Have a great week. Bye-bye.